Welcome to The Explainer. Today we're diving into a massive, highly explosive set of legal allegations regarding the dependency court system. We are going to unpack a complex, 9-year legal battle led by a mother named Renisha Hubbard alongside a group of civil rights activists. Through an absolute mountain of court motions, Section 388 petitions, and raw testimonies, these sources outline claims of a sprawling, systemic crisis within the family courts. Now we're going to look strictly at what the source material alleges, breaking down the specific mechanics of what the filers describe as a multi-billion-dollar operation.
To wrap our heads around the sheer scale of these claims, we really have to start by anchoring ourselves with a staggering figure: $30 billion. According to the source material, this is the estimated annual federal foster care fund that the activists claim is the financial engine driving this entire alleged system. The filings argue that the dependency court system isn't just broken, but is actually functioning as a highly lucrative enterprise fueled by this immense pool of federal money. Okay, let's dive into this. How does that $30 billion actually move, and more importantly, how does it affect individual families? The activists and legal filings describe a macro-level theory they refer to as a kids-for-cash racket. They allege that the financial structure of child welfare creates a direct pipeline, literally from the hospital delivery room straight into the foster care system, monetizing the separation of families. Let's break down the mechanics of how the sources claim this enterprise operates. All right, Section 1, the dependency court allegations. Let's understand the macro view.
To really grasp Renisha Hubbard's 9-year legal battle, we have to first impartially look at the overarching financial claims she and others are bringing against the state. These sources allege that each child removed from parental custody brings the Department of Children and Family Services, or DCS, up to $150,000 per year. To put that into perspective, that's more than double the median household income in the U.S., attached to just a single child. When you multiply that by thousands of children in the system, you start to see exactly why the activists claim the DCS budget swells into the billions.
So where does that $150,000 actually come from? Well, it comes from Title IV funds. These are federal grants authorized under the Social Security Act, and their stated intention is to support state foster care systems. However, Hubbard's filings theorize that these very funds create a massive, perverse financial incentive. The allegation here is that instead of providing resources to preserve and support struggling families, the system is financially incentivized to separate them just to keep those federal dollars flowing in.
Moving on to Section 2, following the financial incentives and mapping out the pipeline.
So, how is a family allegedly pulled into this system? Transitioning from the macro-level funding down to the micro-level, the activists map it out in 4 distinct steps. Step 1 happens right at the hospital. The sources claim that indigent mothers, specifically those on Medicaid, are targeted immediately upon giving birth. Step 2 involves an alleged false positive drug allegation. Step 3 is the filing of a DCFS petition based on that allegation. And finally, Step 4 is the actual removal of the child into foster care placement. This specific sequence is how the sources allege the system triggers Medicaid billing and subsequent DCFS involvement.
The foundation of this entire pipeline, according to the activists, relies on constitutional violations right from the very start. As Renisha Ray states in the provided materials, they secretly drug test you and your newborn without your consent or a medical reason. The sources argue that these secret tests are a direct violation of the Fourth Amendment, specifically pointing to the U.S. Supreme Court ruling in Ferguson v. City of Charleston, which protects patients from being tested for law enforcement purposes without consent.
The source documents present a really stark contrast here. On paper, the California Welfare and Institutions Code, specifically WIC 16000, has a stated legal intent that is crystal clear: to preserve and strengthen family ties whenever possible. But the activists allege a vastly different reality: a multi-billion-dollar kids-for-cash RICO enterprise where families are essentially dismantled for profit rather than being preserved.
Section 3. Breaking down due process and the legal paper trail.
Now that we've mapped the alleged pipeline, let's examine how this actually plays out inside the courtroom. The primary weapon in Renisha Hubbard's legal arsenal is something called a Section 388 petition. Simply put, this is a legal request to change, modify, or set aside a previous juvenile court order based on a change of circumstance or new evidence. Hubbard is using this petition to demand the release of her children, arguing that newly presented exculpatory evidence proves the original allegations against her were entirely fabricated.
Now, what's really interesting here is the specific term the sources use: the big nexus lie.
The absolute core of Hubbard's Section 388 petition is the allegation that DCFS removes children without ever proving a nexus or connection of harm. You see, by law, it's not enough to just allege a parent has a substance issue. The state must prove that the issue renders the parent unable to provide regular care, like food, shelter, and medical attention. Hubbard's filings allege that social workers routinely bypass this requirement entirely, taking children without end medical proof of this crucial nexus.
To pull off this big nexus lie, the sources claim the courts systematically strip parents of their constitutional rights. These due process safeguards matter immensely because they are the constitutional bedrock designed to protect any citizen from unchecked state power. Yet the documents list severe procedural violations in these specific courts, including a complete failure to hold actual evidentiary trials on the merits. They allege parents are never allowed to cross-examine the social workers accusing them. They point to unchallenged perjury in DCFS reports, suppressed toxicology lab results where negative tests are allegedly hidden, and unauthorized waivers of oral arguments by their own attorneys. Hubbard argues she was systematically silenced at literally every turn.
And get this, the fight isn't just against the state. Hubbard actually directs this fight at her own appointed lawyers, stating in a March 2025 motion, Ms. Jarvis's unilateral decision to waive my right to oral argument constitutes legal malpractice. The filings detail how this unauthorized waiver, made completely without Hubbard's consent, caused her intense emotional and physical distress, exacerbating her PTSD as she fought just to simply be heard in court.
Section 4. Ineffective assistance of counsel and systemic oversight.
This brings us to a crucial element of the activist's theory. The sources describe court-appointed defense attorneys not as advocates, but as the glue that keeps this entire alleged racket running smoothly. The legal term for this is IAC, or Ineffective Assistance of Counsel. This occurs when an attorney's performance is so deficient that it actually deprives a client of their constitutional rights. Hubbard's filings level this accusation heavily against major firms like the Children's Law Center, or CLC, and Los Angeles dependency lawyers. The allegation is that these firms have a blanket, unspoken practice of never, ever cross-examining social workers or demanding evidentiary trials.
And how is a systemic failure like this allegedly covered up? Take a look at this number, 22 million. Think about the paper trail left by just one legal case. Now consider that the sources claim there are 22 million missing invoices and workload data reports. Court-appointed lawyers are contractually required to submit these to the Judicial Council to prove they are doing out-of-court work, investigating and interviewing witnesses. The activists allege these millions of records are missing because the lawyers concealed them to hide the fact that they perform absolutely no independent investigations for their clients.
All right, Section 5, the demand for accountability and a decade of filings.
Fighting a system this entrenched takes unbelievable persistence. Just looking at the timeline of Renisha Hubbard's battle shows the sheer scale of these legal maneuvers over time. The timeline traces all the way back to 2017 with the initial removal of Hubbard's older siblings based on what she claims was unchallenged perjury. 4 years later in 2021, she gives birth to a healthy newborn. According to the filings, DCFS filed a new petition on that 2021 newborn simply because the 2017 case existed, even though they admitted the baby wasn't at risk and didn't even detain him. This contradictory logic forced Hubbard to keep fighting all the way into 2025, where she's now filing malpractice motions and fighting temporary restraining orders just to untangle her family from the system.
So what is the ultimate endgame here? The activist demands are outlined very clearly in the source material. They're demanding the immediate return of the children separated under these conditions. They want severe sanctions against the offending attorneys who allegedly waived their clients' rights. Furthermore, they are calling for U.S. Attorney RICO investigations and criminal indictments under 18 U.S.C. 241 and 242 for the deprivation of civil rights. They explicitly draw a parallel here to the infamous 2014 Pennsylvania Kids for Cash scandal, where judges were federally indicted for similar pipeline operations.
We've covered a tremendous amount of ground today, unpacking the severe, multi-layered allegations presented in these court filings, and it leaves us with a deeply provocative question to consider. Where is the line between vital systemic child protection and the absolute right to parental due process? If the safeguards meant to protect families are allegedly bypassed for financial gain, how do we ensure accountability within the family courts? It's a complex issue with profound implications for the justice system. Thank you for joining me for this explainer, and keep asking those tough questions.